Good morning, and thank you everyone for joining us. Today. UTCA is committed to helping our members navigate the highly regulated world of infrastructure construction and is proud to provide you sessions like this in service to the industry. My name is Zoe Baldwin, and I'm the Director of Government Affairs and Communications. And this morning, we're pleased to introduce member firm Cohen Seglius, here to provide an important explainer on how best to mitigate risk and comply with domestic product requirements of the Buy America and Buy American Acts. Cohen Seglius has served clients in several industries, including construction, real estate, financial services, and professional services for over 30 years. And I'd like to thank Sean Farrell and his colleagues Michael Payne and Casey McKinnon for joining us today to share their knowledge and expertise. Without further ado, I'd like to turn it over to Sean, who has more than 20 years of experience representing contractors, subcontractors, engineers, and developers in construction-related litigation at both the federal and state level. Thanks again for joining us. We hope you find this helpful, and take it away, Sean.
Thanks, Zoe. I appreciate the opportunity to speak to UTCA members. We're always happy to do it. This whole seminar idea got kind of kicked off from work that I was doing with Zoe in the legislative committee of the UTCA. When we were there, we were discussing a new act that was being passed in New Jersey called the Buy American Act. You're going to hear us talk about Buy America without an N at the end, and Buy American Act. And when New Jersey was passing the Buy American Act, we decided this might be a good opportunity to give a refresher on what we know about the federal law, which concerns Buy America and Buy American. Now, not to add confusion to this, because it is very confusing, the New Jersey Buy American with an N at the end is the same law as the federal Buy America without an N. So we're going to be discussing Buy America and Buy American. And with me today, I think we've got such a deep bench on this issue with both Michael and Casey here. Michael, by the way, was the chief trial attorney for the North Atlantic Division of the Army Corps of Engineers in a former life before he saw the light and came over to Cohen Seglius. And you can see his entire bio on our webpage if you care to. And Casey is down in DC. He's in our DC office. He's been working exclusively with Mike in federal practice now for years. And he is really our go-to guy on this very highly statutory and regulated area. And to that, I want to give everyone sort of just a primer on kind of how the Buy America, Buy American Act really gets put into an effect, which hasn't happened in New Jersey yet. So I was thinking about my childhood, and I remember if anyone's around my age, when you were a kid, they had that cartoon that would come on to educate you, and it would say how a bill becomes a law, and it had this whole little dance, and it would walk up and down the legislative steps, and a bill would become a law, right? But that's just the first part of it. If that cartoon was to carry over, the next part of it is the regulations, which the regulations tell us how we're really going to enforce that law. So the law is sort of the black and white, here's what I want you to do, but the regulations are how we're going to get that done. One way to think about it, and I was talking to Zoe the other day, and I made this metaphor. I say, you get told a lot when you're a kid, eat well, right? Eat well is the law. That's the Buy America, Buy American law. The regulations are, what's for dinner tonight? How are we getting that done? How am I going to eat well, right? And those are the regulations. The regulations for New Jersey haven't been written yet. Zoe and the UTCA are working with legislators to get those regulations correct. And you're going to see as we walk through this how important that really is. So we're going to ask you for questions, by the way. If you have a particular situation, it's going to be anonymous. You can hit the chat and you can write to us and you can ask us to address questions as we continue. If we see the questions pop up, we'll address them. If not, we'll definitely get to them at the end. But this is your seminar. What we hope to do is really educate you on this area of law so that you can kind of know what to expect. Know what to expect on the federal end for those on the Zoom meeting that are doing federal issues that are concerning the Buy America, Buy American Acts, or now we're going to be moving into a new world where New Jersey is passing or has passed the Buy American Act. And by the way, with New Jersey passing that act, I'll add this: New York already has a Buy American Act, so we know that the port authorities are now going to have to fully comply with the Buy American Acts, which New York and New Jersey are mirroring each other. So without further ado, I want to turn this over to really the experts here, which is Michael and Casey. Michael, I'll turn it over to you so you can start us off on this seminar.
And real quick, Sean, one clarification. We just want to make sure people are aware, any questions you have can be entered into the Q&A box in the Zoom platform here.
Oh, okay. That's a good clarification. Thanks, Casey.
All right. Well, thank you, Sean, and good morning, everyone. Thank you for inviting us. This is a very important topic. And I can tell you in the many years I've been practicing construction law and particularly federal government contract law, there is no topic that makes me as nervous as a question from a client involving Buy American or Buy America, because the wrong answer can expose me to malpractice and my client to a lot of trouble. So these are very fact-intensive issues that come up. There's very seldom something that you can point to as a guidebook and say, oh, here's the answer. They depend on the facts of the particular case, and you have to be very, very careful. This all started many years ago, really 1933 during the Depression, with all the emphasis on, Buy American and trying to build up the American economy. But it's been there all during that time period since 1933. And President Trump in 1917 issued an executive order that brought it to the forefront because his executive order was titled Buy American and Hire America. So as you know, the president was very interested in building up the American economy and protecting us from foreign competition. There are a series of laws, and Sean mentioned it, and Casey will get into more detail. Some refer to as the Buy American Act, which is really a collection of statutes, and then the Buy America Act, which is very different. And whoever came up with the brilliant idea of naming them in such a similar way probably should be shot, because it creates a lot of confusion. Invariably, I'll get a question from a client who'll say, Mike, I have a problem with the Buy American Act. And after listening to him for a few minutes, I realized, no, this is a Buy America Act question. So you have to be careful about the terminology. There are many things that I've been involved in over the years that have taught me about the hazards of this program. And I could spend the rest of our time telling you horror stories. Let me just tell you a couple of quick ones. And I should add that I have not seen situations where a contractor has sat down and intentionally planned to violate these statutes or to deceive the government. It almost always happens unwittingly because they're just not up to date on the rules. For example, I had a contractor who was to install some lighting fixtures in a warehouse at a military installation for the Corps of Engineers. The lighting fixtures were the duty of a subcontractor to procure and install. The sub bought them from a distributor. When they arrived at the subcontractor's facility, the subcontractor noticed that they said made in Mexico on the boxes. And he knew that that could be a problem. So he decided to put stickers over made in Mexico that merely were the name of the subcontractor to cover it up. Not a good idea. The lighting fixtures in the boxes were delivered to the site. Someone from the Corps of Engineers thought, gee, isn't it a little strange that there are these stickers on here? Well, let me peel one off and see what it says. It said, made in Mexico. As you can imagine, all hell broke loose. The contractor who didn't realize what his sub had done was nevertheless exposed to all kinds of things as a result of it. He was threatened with debarment. He was fined double the value of the lighting fixtures. He was exposed to civil prosecution. And it just was a terrible situation that took us a long time to get out of. Another one that happened many years ago was where a contractor was required to install geotextile fabric on an earth moving project that I was involved in. As it turned out, the specs for the geotextile fabric required that the fabric be very large. And there were no looms, if that's the right term, in the United States that could weave fabric of this size. All of the material for the fabric was coming from Georgia. So it was completely an American component. The contractor had the fabric itself, or the cotton material that was to be woven into the fabric, shipped over to Germany because Germany had the capability to weave this in the size that was correct. It was then returned to the United States and installation began. But there's one problem, and Casey will give you the details on this. In order to comply with the Buy American Act, the product must be manufactured in the United States and more than 50% of its components must be American. Well, here we had 100% American components, but it wasn't manufactured in the United States. It was manufactured in Germany. And when the government found out about it, they realized that they had a problem. They directed the contractor to stop. And to make a long story short, this was a potentially $6 million problem. We fought for a year and finally got the Secretary of the Army to agree that there was a significant cost savings in doing it this way, and we were granted a waiver. We would have had a lot less stress if that waiver had been taken care of in advance, and Casey will talk to you about that. So these are the kinds of things that can happen. As you look at the purpose of the Buy American Act, again, it's to show favoritism to American suppliers and American companies. And these are basically what can be referred to as American preference statutes. I think this is a point where there's a poll question, Sean, if you want to jump in.
Yeah, Casey, you want to put up the poll question and we'll do it? Great. So listen, one of the things we want to do is make this interactive so that you guys get the chance to really think through these issues and then maybe even think of your own questions. So you're going to have the opportunity here to answer this right as we're doing it. Are state, local, and municipal contracts subject to the requirements of the Buy America Act and Buy American Act? So we can see here, wow, we got 85% so far saying yes. I'm just going to give another second or so for people to respond. Wow. Well, listen, the overwhelming majority is saying yes to this question. So the answer is, it's a lawyer's question. It's a trick question. There is really no yes or no answer to it. The Buy America requirements attach to U.S. federally funded projects, but not the Buy American. The Buy American often attaches because state contracts may include Buy American requirements into the bid solicitation. So there's really no yes or no answer there. So one of the things to think about is, and what you have to discern is what and who is funding your project and what are you subject to. So that'll hopefully lead us into the next section that Casey, you can elaborate on those requirements for us.
Sure. We'll skip ahead a bit here. So the first act that we're going to talk about here is the Buy American Act. And you'll note that Sean was very careful to make sure when he was either talking about Buy America or Buy American. So the Buy American Act, you'll most frequently see in the context of federal projects. If you're doing work for the US government, typically in a construction project, there are Buy American requirements that will apply. problem is we're not talking about a single act here. There's not a single source or a single law that you can go to look to. It's a series of different requirements depending on the nature of the project, and the specific requirements that will apply are found in the FAR, which is the Federal Acquisition Regulation. And as Michael alluded to, in general, the preference is for domestic construction materials. That's the key you're looking for, domestic products, as they call them. Sean alluded to this. The first step and the most important thing you're going to need to do here is figure out what requirements apply to your contract. When it comes to the Buy American Act, there's two fundamental sets of regulations that will apply. One, I would call the Standard Buy American Act, that applies to any construction contracts performed in the US up to $7.8 million, as well as anything that is set aside for small business. The other set of regulations is known as the Trade Agreements Act. And it looks a lot like the Buy American Act, but it allows you to use products from a variety of different countries that we have trade agreements with. So you could use a Canadian product in the same fashion as an American product. And that applies to construction contracts over $7.8 million. And you'll see at the bottom here, the two primary regulations that you'll deal with on construction projects are FAR 52225-9 and -11. That's the regular Buy American Act, and then the Trade Agreements Act here. So step one is always going to be look at your solicitation, your contract, determine which of those laws or regulations is in there. I will tell you as a warning, the government sometimes gets very lazy and just dumps all of the provisions into your contract. And at that point, a contractor is left to figure out which one really should apply based on the various implementing regulations. And we've had clients have trouble with that because they look at the litany of different regulations in their contract and they think they can choose which one should apply. But in fact, only one will apply, and that can be a costly mistake. If you haven't figured this out so far, as Michael said, this is probably one of the more complicated topics that we deal with in the federal construction world. There's exceptions and waivers and exemptions, and it's a very fact-specific question in every case. You can never determine how it's going to be applied from one contract to another, so definitely reason to be very careful in this area. One common misconception about the Buy American Act is that it only applies after award. This is just something you're dealing with once you're performing your contract, but it has a whole set of regulations as to how it applies prior to award during the bid phase here. So one thing to note about the Buy American Act is that it's a favoritism for domestic products, but not a pure requirement that they be used. So there are ways in which a contractor can use foreign products on a Buy American job and have that blessed by the federal government and have no issue. So in practice, the way this works is in your bid, you can propose the use of foreign products, but when applying or looking at a price evaluation, the government's going to mark up the cost of any foreign products. And under the clause that applies to most contracts right now, that's a 6% markup if you're a large business or 12% to a small business's proposal. Also note that you can submit a proposal that offers up foreign products and then an alternative with only domestic products in case that's what the government is looking for. So it's something that can be used to your advantage prior to award. Now, after award, once you've got a contract in hand, it's no longer a preference. Then it is a requirement that you use domestic products unless you've already told them ahead of time in your bid you were going to use certain foreign products. The only way around that is to request a waiver after award. Michael alluded to cases where that occurs, and there are a series of justifications for a waiver. Three primary ones here. It would be unreasonable cost, non-availability, or it's simply in the public interest to not make us use these domestic products. And one key note here, if the government issues you a waiver and the most common cause is for unreasonable cost, the contractor has to negotiate a modification after award. And what that will look like is if you end up telling the government that I'd rather use this foreign product because it's much cheaper, the government is going to want the cost savings paid to them. That's not going to stay in your pocket. So it's very beneficial to get these things set up in advance in your bid because you're not going to have any cost savings if they come up once you have that contract at hand. And we'll just go through a little detail here about those different waiver justifications, unreasonable cost being the most common issue. You're required to provide the government with some information to support your request. You had to do some market research and then submit a little table that's provided for in the FAR that explains these are the different products available on the market. Here's what the cost differential is, and allow the government to make a determination about what they're going to allow you to install. All right, now into the meat of the Buy American Act. The biggest question you're going to have to answer is, what is a domestic product? We know that the regulations state that you must only use domestic products, but what is a domestic product ends up being a fairly complicated question. You'll note we have pre-February 2021. These are the rules that will apply to most contracts as they stand right now. But in February 2021, there were some changes put into place started by the Trump administration, and we'll go through those at the end. Those will apply to mostly new contracts being awarded now. So in order to be a domestic product for the purposes of the Buy American Act, you have two boxes that must be checked. First, as Michael noted, the product must be manufactured in the US. If it is not manufactured in the US, that is the end of story. If it is, you then must either have at least 50% US components, that's what we call the component test, or the item must be a commercially available off-the-shelf product, which is what we refer to as COTS. The COTS exemption to the component test can be very useful and is often overlooked. So in looking through that test that we just talked about, some key questions come up. What does it mean to be manufactured in the US? What exactly is a component? And what is a COTS product? As Michael noted, whoever put these regulations together did not do us any favors. The term manufactured is not defined anywhere in the Buy American Act or the FAR. So despite the fact that it's the most key part of this test, we have no definition in the regulation itself. But courts have defined manufacture over time to mean whatever process that makes the item suitable for its intended purpose. So that can mean mechanical operations on foreign products, some types of assembly, but whatever is really done at the end to make this into the item you wanted. Some people try to get away with merely assembling a kit, for example. They'll buy a kit of parts from China, bring it over to the US and assemble it. That in itself is not enough. It has to be some sort of real transformation of the pieces to make it into the part that you needed for this job. Next, we want to know, what is a component? So the Buy American requirements as to what is a domestic product apply to any construction material. That's the item that's going to be brought to the job site and installed into the work. So when Sean was alluding to so that's really just what's going to show up at the job site and get installed here. And then we have components, which are the various pieces that get put together to make up that construction material. And that's what's going to be used for that component test, where we're looking for 50% US components. And a component is of US origin as long as it's manufactured here. We don't go into these subcomponents. So all we need to know about the construction material and the components, and this can be incredibly complicated. We've all looked at examples where we know that certain things are manufactured in the US, but the question becomes, are they construction materials or are they components? And those determinations can really make or break the use of a particular product. Again, we can also get away with any product that is manufactured in the US and is a COTS item can be used under the Buy American Act. And a COTS item is simply anything you can buy in the commercial marketplace. It's sold to both private enterprises and the government. This isn't something specially made for the government. And the easiest examples are anything you could go on the company's website and purchase from them. You could go to Home Depot, to a material supplier. If it's available in the commercial marketplace and it's produced in the US and manufactured here, that's all you need to know that that's a compliant product. Now we get into the recent changes that are going to make things even more complicated for contractors. So the Trump administration proposed some rules, and that eventually got incorporated into the FAR for any contract awarded beginning in February of this year. So there were three primary parts of these changes. The first is simply to change the component test from 50% to 55%. In most cases, that won't have a major impact, but if you had a close call in the past, that might cause you some issues in terms of your domestic component makeup. In my opinion, the most significant change here is a stricter set of rules for products that consist wholly or predominantly of iron or steel. For those products, there is no COTS exception, and the costs of foreign iron and steel must be less than 5% of the total component costs. Finally, those 6 and 12% price preferences or markups that we talked about for foreign products were changed to 20 and 30%. So you're going to have a significant markup on any proposed foreign products in your proposal. So we put together an updated flow chart here just to show what the analysis might look like under these new regulations that were put out in February of this year. So before any other questions can be answered, the first question is in our orange box here. It has to be, do iron and steel make up more than 50% of the total cost of the components? And this question must be answered whether it's available in the commercial marketplace, you could buy it at Home Depot or a supplier, it does not matter. We have to answer this question first. And if the answer to that question is yes, then it must be manufactured in the US and less than 5% of the total component costs are attributable to foreign iron and steel. If the answer is no, then we go back to the old paradigm. We find out if it's a commercially available off-the-shelf product, and then if not, is it made up of at least 55% domestic components? So that flow chart can be helpful in looking through these new requirements and trying to figure out whether your products would comply. And oddly, this seems to be the one area where both Democrats and Republicans are in agreement, as the Biden administration has proposed even further changes which would make these requirements even stricter and tougher to deal with. So a few changes, and these are not yet in effect, but they're proposed, would be to establish an office to review all waiver requests, the idea being to try to make them more uniform. Calls for consideration of whether foreign products were made or used, dumped or subsidized foreign iron or steel. I have no idea how that would be used. And finally, create a list of items and products that are considered domestic. This one thing would be helpful in that at least you'd have a list of products that you know could be used that were blessed in advance. Now, as we alluded to before, we also have the Trade Agreements Act, which is much like the Buy American Act. It applies to very high dollar construction projects, and it allows for the use of products from a number of different countries. The list is pretty lengthy here. So you can either use a domestic product, or alternatively, you can use a product that is made in one of these trade agreement countries. And the test is a little different here. It's whether the construction material in the trade agreement countries was substantially transformed in that country. So if we're talking about a Canadian product, the question is not the test about 55% made in the US, all of that. You're simply noting, was that product substantially transformed in Canada? And these are the designated countries that the Trade Agreements Act would allow you to buy products from. Like we said, the list is long: Japan, Canada, a number of small Caribbean countries. There's a lengthy list, but under that provision, it's much, much easier to comply because there are so many other countries you can source your materials from. Do we have any questions on the Buy American Act before we move on here? Doesn't look like it. So then we'll move on to the Buy America Act. So while the Buy American Act and the Trade Agreements Act primarily apply to federal construction projects, the Buy America Act is operating in a very different world here. And this applies to DOT, Department of Transportation funded projects. So that can be federal highway, various rail projects. And those are usually state, local, or municipal contracts that are using funding from the federal government. So the federal regulations now leak down into these state procurements because of the use of federal money. So these regulations came out in 1982 as part of the Surface Transportation Assistance Act. As we noted, they apply to FTA, FHWA, FAA projects, and this is going to come to bear in state and local transportation projects for the most part, infrastructure. And these are domestic content requirements, not preferences. So it's going to operate differently We're not talking in a world where you can propose a foreign product and there's just a price markup here. Unless you are granted a waiver, you simply must use domestic products.
All right, we got another polling question. Hopefully we can all jump on and try to answer this. Can a contractor use products from countries with trade agreements? We just heard Casey talk about that. With the U.S. to comply with Buy America requirements. So I've got Canada, they're in the World Trade Organization, we've got a treaty with them. Can I buy directly from that manufacturer? I'll give everybody a little bit of time.
Looks like we've got a closer race this time. That's good.
Closer race, yeah. Almost have to check our trade agreements before you do your bid anymore. See what countries you can comply with. All right. Well, let's. It looks like the majority of people are saying no. That would be the correct answer. So this is a smart group. Products manufactured in a covered country by a trade agreement, they may be eligible for direct procurement, but you've got to check the regulations. If you were dealing with an FTA project, those regulations still require products being manufactured in the United States, even if you're with a WTO covered country with the trade agreement, okay? That means you still need a waiver. When Casey was talking about those waivers, it's not enough just to rely upon, we got a treaty with Canada, I can purchase directly from Canada. Not necessarily. The regulations are important. Who's funding the project, whose regulations are controlling on your project, what do they say? Again, just to make the example easy, under the FTA's regulations, you absolutely still need a waiver, even if dealing with a country with a trade agreement with the United States. But most of the group got it right, Casey, so they're paying attention to you. That's
Somebody's listening out there. All right, so as we noted before, just to reiterate, the Buy America requirements, these are the entities that are going to be funding jobs where the Buy America requirements will apply. So you see, it's not just rail, it's aviation, highways, transit, substantial infrastructure projects where you're going to see these requirements come to be in effect. And Sean was alluding to the FTA there, and we're going to take a quick look at what the FTA's requirements are with regard to the Buy America Act. This is another case where you have the Buy America Act itself, but the actual specifics about what you'll be required to comply with are going to be found in the specific agency regulations. So the FTA, for example, says that the Buy America Act requires that the steel, iron, and manufactured goods used in the project are produced in the United States. And the FTA's Buy American requirements, as we said, these are third-party procurements. So we're looking at states, localities, transit authorities, airport authorities, and those entities are known as grantees. If the state is granted money by the FTA, they've got to include these requirements within their RFP. And a good way to think about this in general is that the Buy American Act applies pretty broadly, touches almost any construction project for the federal government, but it's a lot looser in its requirements. So there's exceptions and waivers and various ways around it. Alternatively, the Buy America Act applies to a narrower set of projects in the end, but its requirements are much stricter. There's not as many outs, exceptions, and waivers. You're really stuck with American products for the most part, unless you can secure one of these narrow waivers. So, Sean, I think you're going to take our poll question here.
Yep, we got another poll question, everybody. So a contractor specifies in its bid that it intends to use a pump that is mostly made in the USA, 85%, but includes nuts, bolts, and gaskets that are foreign. Would such a pump comply with the Buy America requirements? So it's almost making it, but you got nuts, bolts, gaskets, foreign. thus totality is 85% is US. Does it comply? And it looks like most of the group is saying that it does comply, but a very tight race here. We're almost, give it another second. All right, so it's about 60-40. Let's go with that, 60-40. The answer is it does not comply. Casey made this statement just a second ago. The Buy America Act is very strict. You're either all made in the United States or you're not. 85% is not enough, and it would not comply.
And these nuts and bolts issues, they seem trivial at the end of the day. We're talking about a few screws here or there. But when Sean and I were talking about this proposal, or this presentation, excuse me, yesterday, I was telling him about an example. We had a client that had a single box of Chinese screws that were found on a project where the Buy American Act applied. So they had to not only dispose of this box of Chinese screws, that would be the easy part, but the box was open. So they not only had to dispose of the box, but they had to go around to every guy they had out on the job working and look through his tool belt or whatever boxes and bins they had to make sure none of these Chinese screws had found their way somewhere else. And some of these guys had gone from one job to another, so they also had to go to other projects and dispose of them just to ensure that there was no chance any of these Chinese screws had been installed anywhere. So what can start as a very minor issue can really expand into a major one.
And I'll just add to that, Casey. We'll get to it in a second, and you'll get to it when we talk about the New Jersey statute. But the New Jersey Buy American is the equivalent of the federal Buy America. They specifically wrote it to mirror the Buy America federal statute.
Not that that would be confusing in any way.
No, not at all.
All right. So this will help answer some of the questions that might have come up from poll question 3 here. So we talked about the fact that the FTA requires that steel, iron, and manufactured products are domestic or produced in the US on these projects. And here's what it looks like specifically in the requirements. So if we're talking about steel and iron, the requirement is that all manufacturing processes must take place in the US, excluding certain processes for refinement of steel additives. So when it comes to iron or steel, it really must be produced in the United States. If we're talking about manufactured products, they're produced in the US only if all of the manufacturing processes take place in the US and all of the components of the product are of US origin. So we're not talking about 50 or 55% components here. We're talking about 100%. And this can be pretty difficult to deal with in some cases because it's not just US manufacturing, but almost everything going into it also must be made in the US.
All right, we got another poll question here. So a contractor is required to install new utility poles on an FTA-funded utility relocation project. Would wooden utility poles be subject to Buy America requirements? I think this is a tricky question, but yes, because they would be deemed manufactured products. Yes, but only if they contain iron or steel components, or no, because they are not made of iron and steel. All right, so it looks like the majority of people answering believe it's yes, because they would be deemed manufactured products. About 13% are saying only if they contain iron or steel components, and about 11% are saying no, because they're not made of iron or steel. And jumped up to 80% on the first answer, and 80% of our participants are correct. Yes, the Buy America Act would apply to wooden poles because they would be deemed manufactured products. Can you explain that, Casey? I thought it was steel and iron we care about.
Yeah, and this is a common misconception, or an easy way to get tripped up here is we do think about the Buy America requirements primarily as iron or steel requirements. But at the end of the day, they also do apply to manufactured products. And if you're dealing with something like a wooden utility pole, that is a manufactured product, and therefore you've got to source it from the US. So it doesn't come up on every infrastructure project, but there are cases where you run into these manufactured product issues, and that can be tricky.
All right, another poll question. The best way to learn this is to actually think about it in practice. So would the Buy America requirements be included in a service contract? Yes, no, or yes, but only if you're going to purchase equipment under the contract. 100% of the people so far are saying yes. And the actual answer is yes, but only if the contractor will need to purchase equipment under the contract. Well, we got some, I was too quick. Looks like 50-50 now. I'm sorry. I got 52% with yes. I got 5% with no. And I got 43% with the right answer, yes, but only if the contractor will need to purchase equipment under the contract. All right, Case, explain that one. Service contract, I still got to care about the Buy America Act?
Yeah, and in most cases, the Buy America requirements on a services contract wouldn't apply because you're providing, as we said, services. But if you need to purchase equipment in the furtherance of those services and you're providing that equipment to the government, those would be manufactured products and we would still need to comply.
Right.
So we talked a lot about how strict these regulations are. Everything has to be American, both the product itself and its components, but there are waivers available. And these I would advise to always start looking into during the bid phase here, because it can be very difficult. It can take some time to get a waiver, even if you're justified in one. But we have a few different justifications, or several actually. It can be public interest, insufficient domestic quantity or quality. Use of domestic products would increase total overall cost by 25%. You'll note when we talked about the Buy American Act, we're talking about usually 6 or 12% price differential as justifying the use of a foreign product. Here, it's much more difficult. The use of a domestic product would have to increase the entire job cost by 25%. So if you're looking for a waiver based on cost, it's really going to have to be an overwhelming case you've made that the entire job cost would be up 25% just because I had to use this one domestic product. And most waiver requests are required to be submitted at the time of bid. So this is something to think about in advance. And then they are all posted in the Federal Register, which effectively makes them public law in a way. They're available to see for any contractor, regardless of whether you're involved in this particular project.
All right, poll question number 6. These are tricky questions, no doubt. What would be the best argument for a Buy America waiver for diesel fuel? Unreasonable cost, insufficient quantity or quality, or no waiver is necessary because the Buy America requirements would not apply? Give everybody a second. Everyone is, we're dividing up. Looks like 24% so far are in the unreasonable cost camp. 30% are in the insufficient quantity or quality. And about 45% now, we're doing this live, so the numbers are all moving around. Don't rely on my math, but there are no waivers necessary. So, all right. So about 45% got the correct answer. No waiver would be necessary because finally, the Buy America requirements do not apply to diesel fuel.
And that one is, it's not necessarily intuitive. You might think diesel fuel could qualify as a manufactured product, but the FTA has come out and ruled on this and said that it's neither iron, steel, or a manufactured product, so there are no requirements there. And we've alluded to this briefly, but you also need to be careful if you're working on a state government project, even if federal funds are not in play, because there are state laws, like the New Jersey law we've been talking about that's in the works, or Illinois has a Steel Products Procurement Act. Sometimes the states themselves have requirements that apply even if there's no federal money in there at all. just another reason to very carefully look at your contracts and solicitations to find out what will apply. Now, Sean, we can feel free to jump in wherever you'd like, but
yeah, I think we have a question actually. So let me just jump in with that. So here's the question for the group. What if an owner specifies a product that is not American and you finish and install it? Is the GC still responsible for compliance?
And these situations do come up. Michael, I don't know if you have any input here, but the answer is yes, you would still be responsible for compliance, but this would be something you need to work out with an owner as this came up. So if you notice that it's specified in your solicitation or contract, it's something you'd want to bring to their attention as soon as possible. That would be a situation where a waiver would certainly be justified based on the public interest, or simply because the owner obviously wants this foreign product.
Well, let me change that a little bit, Casey. So if they sole source it, yeah, you'll definitely get a waiver. But what if they say, what if it's a water treatment facility and they give you 3 different suppliers of a major piece of equipment that they need to clean the water? So you have the choice now of 3 different suppliers, and that often happens. Would you think a waiver would be most likely there? Maybe it would. Mike, what do you think?
Well, I think in that case, it would probably depend on which one was the best cost. But, you know, in terms of whether or not if the owner requires something that doesn't comply, whether that gets you off the hook, I would agree with Casey that it does not, because the contractor always has the ultimate responsibility to comply with the law. You know, it could be a mitigating factor if someone tries to prosecute on it to say that, well, I relied on what the owner said, and this is a governmental agency, and I figured they knew what they were doing, or they had obtained a waiver. So that probably would help you. But I wouldn't take any chances with it. If I would always double check. And if you find out that the owner has given you bad advice, I would tell them about it and let them deal with it.
And we run into horror stories of sorts where you've got a handshake deal or an understanding on the job site about what's going to be permissible, but then years down the road, someone else appears to oversee the contract and doesn't understand that agreement or has a different interpretation of things. So getting something in writing, addressing it up front is definitely the best practice here. So we alluded to this. New Jersey is in the process of passing the Jersey Buy American Act, which is misleading because in reality, it is effectively the Buy America Act, but implemented into New Jersey law. Like the Buy America Act, it's going to apply to surface, highway, or bridge contracts. So we're talking about major infrastructure jobs. And originally, the legislation was going to apply only to contracts over $1 million, but it recently has started to look like that limitation is going to be removed, and it will apply to all such contracts. And as we look through these requirements or the draft requirements, they're going to look effectively like the Buy America requirements. So it applies to iron or steel products that are permanently incorporated into the job, as well as their components like nuts, bolts, and steel. And all those items must be produced or made in whole in the United States. Now we're going to have to see what these regulations look like once they're finalized, but as things stand right now, it looks like they will effectively be the Buy America Act, simply in New Jersey law.
Right. We don't know that yet, though. That's the unknown, really. And that's why, listen, all we can do right now is, one, you know, have the UTCA work for your interest to get those regulations as useful to the contractor as possible. But 2 is use the federal side of the house as a predictor as to what could be. It's not going to be worse than the federal regulations. I promise you that.
Yeah, and while the federal regulations are very strict in some cases, at the least we have a lot of information about how those apply. There's cases and decisions about them already. So if the New Jersey statute ends up looking much like the Buy America Act on the federal side, that will still be useful in some regard because at least there's some clarity about what really will be happening.
So we have another question. So I'll jump in. I think it was tagging off of the first question. So I'll remind everybody, the first one was, what if an owner specifies a product that is not American and you first install it? Is the GC still responsible for compliance? And then the follow-up question was, does this include equipment we use on these job sites to perform our work?
The key to answering this question is the second bullet point here, and this would be the same for the Buy America Act. These requirements only apply to items that are permanently incorporated into the project. So if you're talking about equipment you simply bring to the job site, use to get the work done, and then take away, the requirements will not apply. So we're talking only about items that actually go into the job, not just the equipment that you bring to the job to get it done.
Let's say you had a crane and lift items on the construction site, and the crane was not going to be incorporated into the building or anything like that.
Correct.
Probably a highway or a bridge job.
And what is permanently incorporated gets a little tricky sometimes. I dealt with a case where a contractor had to install a certain valve during the course of the project, but before it was finished, that valve had to be removed and handed over to the government as a spare part effectively. Wouldn't be in use all the time, just sometimes. And the question became, is that permanent incorporation or not? I had to give it to the government, but it's not physically in the job site anymore. And we had to reach out and get some clarification from the government on what they wanted to do there.
Right, right.
Then we have the proposed New Jersey rules have many of the same waiver justifications you'd see on the federal government side: lack of availability, unreasonable cost, not in the public interest. And you know, there is a provision here for a reciprocal trade agreement exists for the foreign nation. That, in effect, I think would apply much like a trade agreements exception. So if the New Jersey law looks the same as it does in draft form here, it effectively will have an exception for products from countries we have trade agreements with.
But again, I guess like the FTA regulations, we'll have to wait and see whether or not we can rely upon that trade agreement and just go purchase it, or if they make it more onerous and we still need the waiver.
That being the difference between an exception versus a waiver. An exception would apply automatically, whereas a waiver is still something you would need to secure. So one of the questions we get a lot is, how on earth am I really supposed to manage this process on my project? How am I going to know where all the components of everything came from? And in reality, this is something you're going to have to rely on your suppliers for the most part. They know where the products have come from. They know what goes into these products. And for the most part, we see suppliers with pre-made spec sheets, justifications to tell you where the pieces have come from, where they've been manufactured, where the components come from. And that should help you comply with one caveat, and that is that we often see spec sheets that are incorrect. I've seen suppliers hand our clients what looks like a very formal letter on letterhead put together with some legal help, and it says that these products are 100% from US manufactured components, so you don't have any issues with the Buy American Act or Buy America Act here. But it turns out that product was actually manufactured in China. So just because a supplier promises to you that it's a compliant product, you still have an obligation to take a look and put a little thought into that justification. Because at the end of the day, the prime contractor is responsible. And if the government comes to you and says, we know you've installed a non-compliant product here, it's not simply enough to say, I stuck my head in the sand, my supplier promised me. So you're gonna have to do whatever due diligence you can here, take a look, put a little thought into what you're being promised by those suppliers.
Let me jump in here, Casey, and say this is why, and I know for some suppliers, I think some clients aren't as diligent with the contract terms and conditions in a purchase order as opposed to, you know, subcontractors as doing service agreement as well. But in our purchase orders, we make sure we try to get in there a strict indemnity provision, something that's going to make them liable for their false statements if they're not being accurate as to what's being manufactured where. So on a job where you're relying upon a supplier, and even where they're telling you that it's being manufactured here in the United States, where you've got Buy America Act issues, I would urge you to take a deep look at your purchase order and make sure that there's an indemnity provision in there. So if something happens, because correct me if I'm wrong, Mike or Casey, if something happens with the supplier and he's wrong, you as the contractor are still responsible. You don't get a pass. So you want to be able to contractually go back to that supplier and make him pay you for any fines or anything that, you know, is going to happen to your company because of a result of that violation. You guys agree, Mike?
Yeah, I agree with that, Sean. And I think some sort of a certification is also a good idea from the sub or supplier to you. And I agree with Casey's wording that you have to practice due diligence. What I have found is that there is a lot of misinformation and lack of knowledge about these rules, and that it starts at the top and gets worse as you go down the chain. Believe me, the government people don't understand these rules for the most part either. Even in the federal government, which has been enforcing the Buy American Act for many years, you will find contracting officers representatives who think they know what the rule is, and it turns out that they don't. And then you go down to the prime contractor, whose knowledge is probably one step lower, and then to his sub and to his vendor, and all the way down the chain till you finally get to a point where people don't have any understanding of it. And with the new implementation of these rules in New Jersey, you can expect a lot of misinformation coming from the top. Believe me, the owners and government agencies that you're going to be dealing with are going to be finding their way. And they're going to look to federal experience for the answers to many of these questions.
Well, I'll add to that, Mike. I'll say, if you look at the polling questions that we did on this Zoom meeting, this is a very sophisticated, knowledgeable group of people that are participating here. And we had 60-40 splits on some questions that are routinely faced by people who are on projects with the Buy America Act and Buy American Act. So it is definitely up to the contractor, and I think, you know, organizations like the UTCA to educate the owners about these requirements so that we get it right. Because you can see, just because you are knowledgeable in this area doesn't mean that you always get the right answer. It's a very, as Casey said in the beginning, nuanced weighing of factors to get you to the right answer.
So in the case that you have a problem here, what if the government discovers you've installed some foreign or non-compliant material? The FAR, as far as the Buy American Act goes, and the Buy America Act has similar regulations, tells the contracting officer what they're required to do. So they've got to investigate. If they don't think any fraud actually occurred, if this was just unintentional, like Michael talked about, you got to notify the contractor and propose some requested corrective action. And typically what that looks like is going to be the potential you'd have to remove and replace the materials, pay fines, usually it's treble damages. So not just replace it, but also pay more than the cost of that replacement. You might be terminated for default. And finally, there's potential for prosecution under the False Claims Act, which can really, really have a detrimental effect, not just on the company, but on the principals and the people involved.
If I can jump in there, Casey, on 2 points. The possible removal and replacement. Let's understand that's at the contractor's cost. You're not getting paid to remove and replace that. We had a contractor once with several $1 million worth of guardrail that had to be removed and replaced. I mean, it was a significant hit to the company, but it wasn't you know, U.S. steel. So that was the problem there. And under the False Claims Act, there are criminal and jail term penalties under the False Claims Act. So if you're doing it with intent, you can be prosecuted by the United States Attorney's Office and put in prison. And often people, you know, who are facing those types of allegations, they're not necessarily doing it, like I said, they might be making mistakes that they don't even intend to break the law on, but then be facing criminal charges. It's a horrible position to put yourself in.
Yeah, let me just add to that. You know, I remember a case one time where a contractor was doing a housing rehabilitation project for the Department of the Army, and it involved replacing the tile in kitchens and bathrooms. He dealt with a supplier who manufactured tile in Texas. Well, what he didn't realize is that manufacturer also had a facility in Mexico. to produce the same product. And when it was delivered to the site, they delivered the product that was manufactured in Mexico. And the contractor didn't realize it and pick it up, and they installed many kitchens and bathrooms using this tile before it was discovered. Once it was, the government said, well, this is a Buy American Act violation, and you're going to need to rip it out and redo it. We, of course, went after our supplier and said, how can you do this? And of course, it was their fault. And I was able to negotiate a deal with the government where I said, look, how about you let us leave the tile in place and save us the horrendous labor cost of stripping it off and replacing it. And in return for you, we will give you a credit for the material cost of the tile, which of course we took out of the hide of the supplier. And the government agreed. So sometimes there's a practical resolution to these things. And that was one time where there was. But, you know, while I'm on that topic, it's so important to maintain a certain degree of education about these things. You know, when attorneys go to law school, they're taught not to know the answer to every question or to know all the laws. They're taught issue recognition, to know when there is an issue and then know where to go to find the answer. You need to make sure that your field people, your purchasers, your supervisors recognize that there may be or is a Buy America or Buy American Act issue, and then go somewhere to get the answer. Because the federal government treats many of these questions as ethical questions. I've had contractors who got in trouble because they didn't ask the question through the management chain as to whether they were permitted to use this product. And the government was not only concerned that they went ahead and violated the Buy American Act, they considered it to be the lack of an ethical culture, because within your company, you didn't have a system to find the right answer. You didn't even recognize that there was a question that needed to be answered. So although this is going to sound like a commercial for lawyers, I can't stress enough, go to someone and ultimately probably get legal advice on these things, because they are very tricky and the answer can be very critical.
And our slide up here speaks to what you're talking about, Michael. And you have to have a process in place to track the country of origin of your projects, what's being incorporated into them. You have to have certifications from your subs and suppliers. And effectively, you want to document that you've done everything you can to comply, because nobody's perfect and mistakes are made. But if you have these documents in place, if the government comes to you and says, we have a problem, you can at least show, no, look, I have a system here. I was doing my best to comply. I got certifications. We were tracking all of this. This was just an inadvertent mistake. In that case, you're likely going to avoid some of these more terrible outcomes that we've talked about here. You might get more of a slap on the wrist, or maybe just have to replace the materials, but you're not going to be in a position where you're going to be facing gigantic fines or jail time. So this is a way to kind of mitigate that risk, much like the indemnity provision Sean was talking about in your subcontracts. And if all else fails, you have to go to the government, disclose what you found, provide them with an explanation as to what happened. You're going to ask for a waiver. You have to explain why you didn't ask for it in advance. And as we talked about, bring your checkbook, because if you save money using foreign products, the government's going to expect that money be paid back to them. And just to kind of summarize in the end, Michael talked about this. Keys are: be familiar with whatever requirements apply, check your solicitations, check your contracts, make sure your whole team, not just one person, understands what applies to a particular project. Make sure you flow those provisions down in your purchase orders and subcontracts. Make sure your QC personnel actually are looking at the materials when they show up to your job site. So sometimes you can catch problems in advance that way. Someone tells you a product is made in the US, but it shows up and it has a Made in China sticker right on it. One way you can avoid issues. And treat any potential violations as serious. Notify people, work with the government, and try to get out in front of these things rather than trying to hide them.
All right, so that brings us to a conclusion. Before I turn it back over to Zoe, let me suggest that you take this PowerPoint. You can get it from the UTCA. There's a lot of great information in here. Give it to your team. I would have a discussion with your team, your estimating department, your project managers. Let them know these issues. Let them understand these issues so they can help protect the company. And I would go so far to say is that team could also be your professionals. Take it to your attorney. Get their advice on these things, as Mike said. Make sure that you're compliant with it and document. So with that said, if there are no other questions, if there are, we're happy to answer them. But I don't see in the Q&A any more questions right now. So Zoe, we've gone a little bit over the hour that we promised you. There was a lot to put in there. We've said a lot here today. I hope everyone, like I said, gets from Zoe the presentation so you can go back over it. I love what Mike said about issue spotting. The best attorneys don't always know the answer immediately, but they see the issue and they go find the answer. And that's what you need to do here. And you can use this PowerPoint, I think, effectively to get that done. And that was our goal, to educate you guys and give you something that you can start using tomorrow to make your companies a little bit safer with these requirements. So we thank everybody for the time. Zoe, we thank the UTCA and you for allowing us to come and talk about this issue.
Oh, thank you so much. And don't even apologize for going over time. That was an incredible amount of information that you were able to pack into this hour. And I really hope everyone found today's session useful. We're going to be following up, as Sean said, with an email with the slide presentations for everyone to use as a reference. So thank you, Sean, Michael, and Casey for this in-depth explainer. These are such complicated processes, and I think it's helpful for everyone, even if you navigate them currently, as we saw with some of those quiz answers. It's always helpful for a refresher and to have knowledgeable people around us to help navigate. I'd also like to just say that UTCA is always on the lookout to bring information and helpful presentations such as this to our members. So we're always open to suggestions. So for those of you participating, if there are other things that you would, and topics that you would like to hear from us and have a panel discussion on like this, please reach out. Never hesitate. So thanks again for joining us. We look forward to seeing everyone at our annual convention, September 30th to October 2nd at the Tropicana in Atlantic City. And also please feel free, if you have a question after this session on this issue, please reach out, and either one of the attorneys here or UTCA will absolutely help you get those answers. This isn't just a one-sided conversation. So again, thank you so much, and we look forward to participating with you guys.
Thanks, Zoe. Appreciate it.
Thank you.
Yeah, thank you.